rights. We appreciate that the common thread coming from our partners is our call to action and the spotlight on the judiciary that is advancing the entrenchment of human rights, not only in Kenya, but also in the region. So thank you very much, our wonderful partners, and we please convey our thanks to your leadership and say we will continue to foster the partnership that we have established going forward. So without much ado, allow me to invite the ICJ Kenya Chairman, Professor Sainde, to give his opening remarks, and thereafter we have our Justice Dingake is online and ready to deliver his keynote address to us.
We are glad to partner with all of you in the conversations we are going to have in the next few days. Judiciaries, for us, play a critical role in advocating, in protecting sexual reproductive health and rights, not just in Kenya, but in the continent. Not just national judiciaries, but also regional and sub-regional courts. So for us, it is a critical reflection at this point with the rest of the partners in this room. We have seen changing trends across the continent. We have made progress in some countries. Recently, Mauritius, for example, passed a critical decision striking out provisions that are similar to Kenya's provisions of sections 162 of the Penal Code. But we have also seen regression across the continent. Some countries have gone back to where they'd come from, either in passing regressive laws. It's worth mentioning that Uganda the other day just passed a law that made worse the situation for those who identify as LGBTQI communities. As we see varying trends on the continent, but we also see consolation and progress driven by the judiciaries. And therefore, the conversation we are going to have is so critical to keep reflecting on the trends we are seeing and how the judiciaries remain a critical player in advancing human rights, and for us in particular, reproductive rights. As we make progress, we can't lose sight of the regression across the board, fueled by various actors that are not just national, but also transnational. It is therefore necessary that as we consolidate our efforts in country, in Kenya, we also consolidate regional, continental efforts, but we also link them up to global efforts to try and advance health rights, reproductive rights, human rights, but significantly deal with regression across the human rights sector. The conversations we are going to have for the next 2 days, you've just said it's not 3, will be timely, and for us at the Center for Reproductive Rights, we remain committed to ensuring that the entire African population, focusing in particular on women and girls, enjoy the protection of their reproductive rights in law, in policy, and in progressive administrative actions across the board. We thank you and wish you a successful week, successful deliberations. Thank you very much.
On behalf of the Kenya section of the International Commission of Jurists, ICJ Kenya, we are pleased to welcome and host you here in Malindi at the 2023 Annual Jurists Conference. I sincerely thank you all for honoring the invitation and joining us today.
I can't hear.
Today marks the first day
I don't know this thing.
of the 2023 Annual Jurists Conference, and we are honored to host it here at this beautiful place with all of you. Before we begin, I would like to sincerely thank ICJ Kenya, the Secretariat, I would like to thank ICJ Kenya partners for convening jurists in the region to discuss trends in judicial accountability and human rights in Africa. We could not have done this without you. Distinguished jurists, this conference is timely as it distills significant and considerable topics for discussion. In keeping up with this year's theme, Jurists' reflections on the trends in judicial accountability and human rights in Africa, it is essential to note that judicial independence and accountability are fundamental guarantors of credible justice. Moreover, international legal instruments recognize and emphasize the importance of judicial independence and accountability. For instance, the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights guarantee everyone equality before the law and a fair hearing by an independent and impartial tribunal. I invite you all to explore the normative congruence between judicial accountability and independence and the critical role of judges in promoting judiciary institutional accountability. Distinguished jurists, this conference will further provide a platform to interrogate access to justice as a measure of an accountable and independent judiciary. I wish to remind you all that access to justice is a core fundamental right and a central concept in the broader field of justice. It involves normative legal protection, legal awareness, and legal aid. The blueprint of the judiciary on social transformation through access to justice appreciates that justice is cross-cutting, broad, multifaceted, and that it is imperative to expand doorways of justice by adopting a multi-door approach to access to justice. To breathe life into the vision of the judiciary, this conference will provide a platform to interrogate alternative and appropriate models of access to justice, especially for the poor and marginalized groups in Kenya. Distinguished jurists, the overarching theme for this year's AJC will also provide a wholesome platform to engage on human rights. The conference will highlight the relevance of a human rights-based framework in addressing topical and contentious issues on sexual and reproductive health and rights in Kenya. I welcome you all to explore the recent developments, constraints, and opportunities relating to advancing sexual and reproductive health and rights in Kenya and Africa as a whole. Covering topics such as access to reproductive care and gender identity, this conference will discuss the impact of culture, morality, and social beliefs, and the enjoyment of sexual and reproductive health and rights in the region, particularly in relation to vulnerable and marginalized groups. I call upon you all to underscore the role of litigation, national human rights institutions, and regional human rights bodies in advancing the realization of sexual and reproductive health rights in the region. Distinguished jurists, I welcome you to interact, connect, and share ideas on the exciting topics brought forth by this conference. Again, I thank you all for joining us today and look forward to fruitful deliberations. Karibuni Malindi.
Thank you very much, Chairman. Thank you.
It's a singular honor and privilege for me to have been invited to address this distinguished gathering of jurists assembling in Mombasa today. Although your invitation came a bit late, I couldn't resist it, primarily because it came or was conveyed through the person of one Arnold Tsunga, who I hold in the highest respect, and one of Africa's finest sons when it comes to defending the rule of law, human rights, and good governance in Africa. That is one reason. The second reason why, although your invitation came late, I couldn't turn it down, is that I have a long association with the International Commission of Jurists, the Kenya section, dating back to the days of George Kegoro. So it is a singular honor for me today to have been invited to speak to you on the dynamics of judicial accountability and independence and its impact on the human rights in Africa. As many of you would certainly agree, in law we say context is everything. The discussion of the interrogation of the dynamic of the independence of the judiciary and accountability does not and cannot take place in a vacuum. It takes place within a particular context. In Africa, the African legal landscape is uneven, particularly its varied constitutional frameworks. Each constitution in several African countries has unique provisions. And we come from different contexts, divergent historical and cultural, socio-political contexts, including the state of democracy in many of our countries, or even the absence of democracy in many of our countries. What, during the course of my presentation today, I'll refer to simply as democratic recession or a democratic deficit. Because in the last few years, we have seen the African democratic project basically oscillating, behaving like a pendulum. On one hand, there would be what appears to be a promise of the nurturing and even consolidation of democracy. But the last few years have been characterized by democratic recession or democratic backsliding. That is the context within which we must interrogate this particular topic today. What is particularly important as part of just sketching in broad strokes the context within which we must interrogate this topic are the following features of the African continent insofar as democracy, the rule of law, and good governance is concerned. The democratic recession or deficit I speak of on the main is characterized by the following key features. A phenomenon of the big man syndrome lurks around many of our countries. We have also weak institutions that are supposed to support the democratic project. We also have the tendency of the ruling class or the ruling elite using law and the legal system, including the judicial system, as a weapon against its opponents, what I may refer to as the weaponization of the legal and judicial system. We also have the phenomenon of state capture of key institutions of governance, including in some countries, I will not mention names, even the capture of the judiciary itself, which is supposed to be the bulwark, the last line of defense when it comes to defense of human rights. I was characterizing the context within which these topics must be interrogated, and I was speaking about an epidemic of bad laws among the features that characterize the current context, including a compromised selection method of judges and the phenomenon of what we call cadre deployment. Now, that is the context under which we meet today that we must always bear in mind. The influence of Western notions and symbolism in African legal systems is pervasive and unmistakable. Themis, the goddess of justice, is everywhere around us. The symbol of justice is shown as blindfolded, with scales and a sword. The scales reflect even-handedness. The sword is a symbol of power that executes decisions without sympathy, without compromise, without ill will, or without favor. The inclusion of the blindfold in justice imagery in the Western world coincided with the establishment of independent and professional judges, as we all know. These judges stood apart from the king or the emperor and did not simply act on the orders or instructions of the king or the emperor. The goddess of justice is blindfolded so that she cannot read orders and instructions of the executive authority on how to decide a case. The blindfold communicates the idea that justice should be administered without fear or favor, without ill will. The blindfold justice acts solely on the grounds of reason based on the facts and the law. Intellectual rigor and thoroughness, including knowledge of the law, are her only guide. In Africa, the above virtues of a judge, an independent judge, a professional judge who does not respect persons but only respect the law, may appear far-fetched and even over-romanticized. The mass ownership of this imagery of justice appears to be at its infancy in our continent, and now and then governments show this deep disdain for it. Often, whilst a few elites in Africa may feel outraged by government disobedience of court orders or an appointment of a judge based on other considerations other than merit, most of our people may not consider this an aberration at all, despite the fact that this example constitutes a clear travesty of the rule of law. Judicial independence is indispensable in a democratic order. Judicial independence has been seen as fundamental, and not just to the rule of law, but to constitutionalism and good governance. As many of you here, plainly very learned by virtue of carrying the title jurist or lawyers, would understand that there is a huge difference between constitutionalism, constitutionality, and constitution. Because as we all know, constitutionalism speaks to this idea or this notion of a limited government. We have in our continent many countries that have constitutions, including very beautiful constitutions, but are strangers to the notion of constitutionalism. So constitutionalism, the rule of law, the independence of the judiciary is an imperative element when it comes to matters of fair trial. Judicial independence should be seen not as an end, but as a means to an end, a means to achieving certain ends. If judges are independent, they can best guarantee human rights. It's only when judges are independent that they can hold other co-equal arms of government accountable, including the executive and corporate giants. Whilst the desire to have an independent judiciary is fairly critical in many democratic societies, there are certain important factors that we should always bear in mind. The judiciary as an institution and the judges do not operate in a vacuum. For over 20 years in the bench, I can say to you confidently that I know of no single judge who came to the bench as an ideological virgin. None of us come to the bench as ideological virgins. We are all conditioned and shaped by the socio-economic and cultural circumstances that produce us. So this confrontation that the judges must meet relative to the socio-economic realities are real and may actually impact on the judgments that they give. Now, this notion of the independence of the judiciary, including the accountability of the judiciary, are critical. International law is replete with support of these ideas that I am talking about. And the International Covenant on Civil and Political Rights, the Universal Declaration of Human Rights of 1948, including regional instruments such as the African Charter on Human and People's Rights, and many other allied legal instruments, they speak of all these notions of independence and accountability. Principle 1 of the United Nations Basic Principles on the independence of the judiciary says that the independence of the judiciary shall be guaranteed by the state and enshrined in the Constitution or in the law. Many of you will testify that the independence of the judiciary is enshrined in your constitutions. That alone, I'm afraid, is no guarantee of independence, as we all know. But it's important as a precondition that it must be contained in a constitution. Over the years, I may have come to this realization that whilst I agree with the assertion contained in Principle 1 of the United Nations Basic Principles on the independence of the judiciary, I have come to realize that the virtues of independence, accountability, and constitutionalism lie best in the hearts and minds of judges, men and women of goodwill, who hold these principles dearly and who are willing, as your former Chief Justice Maraga said once, who are willing to shed blood for these principles. Only then, when you have the caliber of such judges, and you in Kenya have been blessed with a few of them, I just mentioned what Maraga said, only then can you say that some progress or there is hope for constitutionalism that is derived out of an independent judiciary. You also need judges whose intellectual thoroughness is not in doubt, who produce judgments of a particular pedigree in terms of quality that you can say enhance the credibility and gravitas of this all-important institution I have been privileged to serve, called the judiciary. And again, in Kenya, you have been blessed with such jurists who have depth, intellectual depth. And again, I cite your former retired Chief Justice, William Mutunga, as an example. So we need all those factors in order to give effect to the independence of the judiciary. Otherwise, it can just be something that is contained in constitutions and not beyond, because we need judges who, as guardians of the Constitution, can effect the promise of the Constitution. Sometimes not just through knowledge of the law, which is critical, but sometimes because of courage. It's a pity that in many constitutions I've read, while courage is critical to dispensation of justice, it is hardly prescribed as a qualification. But I dare say, in the business of judging, the obligation to remain independent, including to account, as I'll explain, is also a function not only of intellectual depth, integrity, but also a function of courage. And I say that for a fair trial to be fair, the judge or judges sitting on the case, of course, must be independent. All international human rights instruments that I have no time to single out speak to this idea. The Human Rights Committee has repeatedly taken the view that I wish to emphasize today, that I hope it finds resonance in your hearts, is this: the right to an independent and impartial tribunal is an absolute right that may suffer no exception. I hope this can settle in your hearts and minds that this is one absolute right, and the law hardly recognizes that rights could be absolute. But this one, the independence of the judges of the judiciary, is an absolute right that may suffer no exception. And even though a person's right to a fair trial may be respected in a particular case, when a judge is independent, a state will be in breach of its international obligations if it cannot guarantee an independent judiciary. Two things that I'm sure you know that are the pillars of an independent judiciary. First is the institution itself. It must be independent. Second is the judge. The person of the judge must be independent. And that is where courage comes in. But when it comes to the institution, there are too many other factors that have a bearing on the independence of the judiciary, including the selection process, how judges are being appointed. In Africa, I've already bemoaned what I call cadre deployment, where politicians, scared of an independent judiciary, deploy those persons who they think are weak on principle or integrity, and they deploy them to the bench with the hope that in so-called high-stake cases, these judges may come to their rescue. So that can be a real challenge. You see, Director of Proceedings, you'll pardon me if I get carried away discussing some of these issues and forget that you have actually given me 10 minutes to speak, or 15 minutes. So I am going to cut to the chase with respect to what remains, and that will be on the issue of accountability. I've spoken a bit and at some length about independence. I want to speak about accountability. While judicial independence forms an important guarantee, it also has the potential to act as a shield behind which judges often hide in order to avoid being accountable by engaging in unethical conduct. For this reason, judges must conduct themselves according to certain laid down codes of conduct. I have served in more than 3 jurisdictions, including one international jurisdiction at the Residual Special Court of Sierra Leone. And I know that judicial codes of conduct are very important tools that can be used in order to ensure that judges are accountable. Accountability is complementary to independence. It's essential in terms of ensuring public confidence. The judiciary in any democratic state exercises delegated power by the people, and it is entrusted with providing a very important service to the people. I know of many judges, including many lawyers, who would quibble or contest the idea that judicial work is a governmental service or is a state service. Today, I want to put it plainly and clearly that it is. And it is essentially because of the fact that judges exercise delegated power from the sovereign, being the people, that we must be accountable to those people. We are not sacred cows. We are not untouchables. We are not demigods. And we do not have the monopoly of wisdom even on matters of law. We should allow ourselves to be questioned by the learned and those not so learned, who must call us to account for our decisions. And we should humble ourselves and be able to account, because accountability goes hand in hand with the independence of the judiciary. Now, how do judges account? And to whom are judges accountable or responsible? We account in so many ways. One of the ways in which the judiciary is accountable is that we sit in open court and we place no restrictions whatsoever on any person to attend, because we live transparency. That is one. Two, we are accountable in terms of the judgments that we are required to give. Every judge is required, for any decision that he gives that impacts on the people, to give reasons and to chart a clear path of how he or she came to that conclusion, so that an army of scholars and other critics can actually be able to call this judge to order or to engage this judge and say, this was not correct or this was wrong. So we account in that sense. In some other jurisdictions, including the judiciary where I currently serve, in PNG, we give annual reports every year and account to the people about how we exercise that delegated power. I know in Africa it is done in a few countries, but it's not in all countries. And this is indeed a very important practice. The wretched of the earth, the homeless, the weak, the landless, those who have been unjustifiably robbed of their possessions, those whose rights have been violated, need an independent and accountable judiciary. And they should be assured, including the marginalized, persons with no name recognition, that when they step into our courts, litigating against whosoever, whether called government, prime minister, or president, that before a judge, that doesn't matter. Because as I've said, consistent with the notions of justice, the justice imagery that I started about, it matters not, because judges are not respecters of persons. Judicial accountability of necessity differs in character, and it may vary from one country to country. It also impacts on issues of discipline. Judges can be unethical in their conduct. They can fail in delivering justice timelessly. Some judges are known to hold judgments, to have pending judgments for years. All this requires some disciplinary mechanism in terms of which judges can account to their peers, account to the Chief Justice, and if need be, account to the public. So who are we responsible? Who are we accountable to? This question has always been with us for the longest time. Some people say we are only accountable to our own conscience. Others say we are accountable to the Constitution. Others say we are accountable to the law books that usually surround us. A friend of mine in Botswana, a literary giant, I call him, one Justice Moroka, has once cautioned me that this accountability to one's conscience may be problematic because some judges' conscience may not be aligned to the Constitution or the imperative of constitutionalism. And as a result, I think he settles for the view that judges should be accountable to the Constitution. It may be a better view than that judges must also be accountable to their conscience. A story is told of a conversation between Justice Leonard Hand, many of you may know, a distinguished jurist in the United States of America, who had a conversation with his clerk called Sonny, and he asked Sonny, to whom am I responsible? He said, no one can fire me, no one can dock my pay, even those justices in the Supreme Court who often reverse me, they can't make me decide as they wish. Everyone should be responsible to someone. And so he continued to pose the question rhetorically, to whom are we responsible as judges? And he turned to look at the books and said, it is to these books that we are accountable. I think that underlines the way judges feel about accountability and to whom they are accountable. Now, all these, the independence and the accountability part speaks also to certain attributes of judges. What are the attributes of judges the judges must have in order to be independent and accountable? I have said a few of them earlier. One British Lord Chancellor is alleged to have said in answering this question that he said about the qualities of a judge in order to enforce accountability and also independence, said, I like my judges to be gentlemen. If they know a little law, so much the better. Many of us here would take objection to that statement by the British Lord Chancellor because they require of their judges to be knowledgeable about the law. Earlier on, I spoke about cadre deployment, and many of the politicians who rule Africa on the main think that they can get anyone, those people who may not be deserving of judicial appointment, so that they can cover their back, so to speak. But usually that can be a very risky exercise. As most jurists in the United States of America will tell you, when you appoint a judge, you are taking a risk because there's no guarantee that he would, after the appointment, continue to take your instruction. There is a saying, one US president was once asked the question in relation to appointment of judges. And he was asked, Mr. President, have you ever made a mistake? And the president said, yes, I made 2 mistakes, and both of them are sitting in the Supreme Court. So that speaks to the risk that you take in appointing judges and believing that you can compromise their independence. I have spoken for a long time. I want to wind up my discussion by discussing what needs to be done. What do we need to do in Africa to ensure that judges are independent and accountable? I think the first port of call, we need to reform our laws, our constitutions, to make this beyond any shadow of doubt. 2, we need to improve the manner in which we appoint judges, so that the appointment process is based on merit. And the persons who are sent to the bench have a demonstrated track record of intellectual rigor, independence, and integrity. That is very important. We also need to make our people aware that ultimately the ultimate protectors and defenders of the Constitution are themselves. And they can only do so if they know their rights, if they know their system of government, if they know what to expect of judges. We also need to strengthen the institutions that support democracy in our region so that we can resuscitate our democracy, because earlier I spoke about democratic recession, democratic deficit, democratic backsliding, which we need to reverse. But the independence of judges, as I said, is an absolute right that should suffer no exception. I wish to conclude by saying the following. We need judiciaries that cannot be compromised. We need executives that understand the importance of the judiciary to the people and who can appropriately fund the judiciaries and not starve them of funds and resources. Because if you do so, then you are compromising the very essence of the independence of the judiciary, and you are indirectly punishing the people who are dependent on an independent judiciary. Judicial accountability and independence must be safeguarded by everyone, including you, the judge, the lawyers. You must be able to defend the rule of law and the independence of the judiciary, not for the sake of judges, because this is a public good, but for the sake of the people. If this is done by the lawyers, by the public, and all other institutions, Africa will be a safer place to live in, because the rule of law will be respected. Director of Proceedings, allow me to thank you for your kind attention. I may have spoken more than the 10 minutes you assigned to me, to which I proffer my sincere apologies. Thank you very much for your attention, and I wish you a wonderful 2023 annual Jurist Conference. Thank you, Director of Proceedings. Thank you very much.